Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Jurisprudence class number 20. So, in this video, we are going to discuss the sources of law. Friends, you are all well aware, during the family law, you might have been told about the Smriti, Shruti, Yagnavalkya, different schools of thought like Yagnavalkya Smriti, like Mitakshara school, Dayabhaga school, all these things are there. I am sure you all know the same, but we will discuss the other sources of law. So what is a source? Maybe a law or what is maybe a scientific principle. The source means, please listen, from which the topic, for example, since we are discussing source of law, source means the from which the law derived its authority, from which the law derived its force. This is what is called source. So simply we can say sources of the origins of law. And please remember, it may be in the shape of law, it may be in the shape of natural rules, it may be religious rules. So these rules are used by the state to govern its subjects or to govern its territory. Right? You all know that over decades ago, the rules or the principles of law, they have emanated from the customs. So custom is the best source of law. That's why in the class I told you, custom is to society while law is to the state. Don't forget it. Custom is to society whereas law is to the state. Please remember. So while taking up the sources of law, so right from the kingdoms, so the human rights, the natural rights, the legal rights, the civil rights and the common law, all of them, they emanated as the unwritten sources of law. UDHR, Universal Declaration of Human Rights, 1948, 19th century, it's a declaration. It is relating to human rights. The rules, regulations, they are forming part of the law. So this is important. And before our IPC, CRPC and other things, the common law of England, it was in vogue. So common law, particularly the religious law, they formed the basis for the formation of the present day law. And you know, yesterday binding authority, precedents, stare decisis, ratio decision, all these things, they also are the very good sources of law. I told you they are material sources only. They do not form the law. They are only useful for the framing of the so-called. So please remember, the legislation, you all know, legislation, the best source of law. So delegate legislation, supreme legislation, subordinate legislation, all these things are there. Now, the sources of law are of two types. One is formal and second is material. Formal sources, because the formal sources are from the statutes, Indian Penal Code. So it's a statute, legislature has made it. Or legal sources, they contain legislations. Precedents are also formal sources. Certain agreements, they are also formal sources. Declarations, they are also formal sources. So professional opinions, they are also formal sources. So normally it's all related to the history. Then what is material source? Please remember, material source means the source from which the matter is derived, but not validity. We can't say whether it becomes law or not. It is only a source, material source. For example, foreign judgment, foreign precedents, definitely they are legal material sources of law. So please remember, Keaton, very famous jurisprudence, he defined the sources of law as those from which the law is eventually fashioned through judicial activity, through the precedent, through the professional opinions and the principles of morality and equality, they are more important. Now coming back to our Hindu law, sources of Hindu law, you all know our Hindu law has got the oldest pedigree of known system of jurisprudence. We have to boast ourselves. Nalanda, Takshashila universities were also there. So, Vijnaneshwara, he is the founder of Mitakshara school. He showed the means to know the law. Yagnavalkya and Narada, Yajnavalkya law, school generally deals with the civil law. And No.20, it deals with the kinds of customs. And ancient Hindu sources are, Smriti, that is, which were heard from Vedas, 6 Vedas, Samaveda, Yajurveda, Akarveda, and commentaries and digests also. Then Smriti. So Justice Markandeya Kanji says only Smriti. Right, Smriti means which was remembered. So Dharma Sutras, which decided Acharamu, Vyavaharamu, Prayachitamu, marriage, customary law. So third one is customary law. It defines so-called marriage and inheritance. And as regards Smriti, please remember, in the case of Anju Bai, B-A-I, versus Hemchandra Rao, 1960, it was held that the commentaries, they do not enact the law. They explain the law. They interpret the law. That's all. Evidence of customs. So already customary law, when it comes to customary law, we'll take up a separate issue and I will discuss the importance of the customary law. So please remember, the original sources, the sources, they relied upon the basic values, the norms and the standards of the fair play, fair justice and priority. So please remember, Supreme Court in the case of Krishna Singh versus Mathura Ahir Mutt, 1981. So here actually this is a civil case under Order 32, Rule 29 CPC. So if at all the court wants to file a case, if at all the Mutt wants to file a case, they can file under Section 92, that is trustee has to file. And this is all regarding the protocol in regard to that so-called Mutt properties. And actually Allahabad High Court stated that the discriminatory ban on Shudras by Smritis stand abrogated. So this is regarding allowance of allowing some people into the temple. So here they said that please remember. So the decision that please remember, the customary practice is banned. Sometimes custom may not be accepted by law also. So please remember, we all know that Hindu law is rigid. Definitely it has been criticized for its orthodox and patriarchal character. Orthodox, conservative mind. ఒక సిద్ధాంతం చెప్తే దాని నుంచి రారు. Then patriarchal society. Father is the head of the family. It does not have modern outlook of the society. మమ్మల్ని తిట్టినట్టే. We don't have a modern outlook. So proper codification of Hindu law without ambiguity, it is the need of the hour. Of course, slowly basing on the sources like formal sources, material sources, schools of thought, and also customary practice and the Shruti, Smriti, basing on all these things, the present law is based. But what is the present source of law? Please remember, the present source is justice. Present source is equity and good conscience. So please remember, whenever a dispute comes before the court, so it can be settled only by the fairness, justice. Justice means being fair. I don't favor this party, that party. That is justice. Then equity, already gave you. So proper ratio and proportion, equity. Suppose you can't fine 5,000, impose a fine of 5,000 rupees on an auto driver. 500, that is equity. Equality in other words. And good conscience. So before delivering the judgment, you must maintain the composure. CLM, composure. You must be conscious of the legal provisions. You must have good conscience about the legal provisions. If you are confused, if you are in another state of mind, definitely I am sure that you can't give any proper judgment. So the present sources are justice, equity and good conscience. So please remember, these are the important sources of Hindu law. And I already told you the formal sources and the material sources. Sources means the from which the law is derived. If you know this much, it is sufficient. So with this, I am concluding. Thank you very much.